So it's time for the another session on PCT International Searching and Preliminary Examining Authority, ISA and IPA. So I would like to request Mr. N. Ramchander, Joint Controller of Patents and Design, Head PCT ISA IPA Division, to speak on the topic.
Good afternoon, everybody. It's already we are moving ahead of time, so I can reduce my slides as much as possible, which is already been covered by our previous presentations. And we know this slide must have been covered by our Robert, WIPO delegate. It is just the outline how the PCT application will be moved from invention to national phase entry, and finally how it is to be granted. Next, this slide which shows the two routes of application filing internationally. One is traditional route, second is PCT route. In the traditional route, we know that application has to be filed within 12 months from the date of filing. Whereas in the PCT route, there is certain single application has to be filed to enter into the in any countries where we can have time at least 30 months of time. Now, Robert, he has explained about the objectives of the PCT and advantages, and he also prepared the module. He opened the account in the ePCT module, and then he prepared the draft of the specification. Then Rohit, he has processed it, and he has issued the demand letter for making the payment, and the applicant, he has made the payment. Now, the application has gone to the ISA section. Then when application goes into the ISA division, then what ISA will do? ISA has to be chosen by the applicant. In case if applicant wants to choose a good ISA, then what is requirement? More importantly, the language. If the language is other than English, then they will have to bear the translation cost. Then preferably Indian applicants would choose the English searching authority, preferably India. This is the India, Australia. These are the countries where the English, the search report can be issued in the English language. International Searching Authority, ISA. What it does actually, once the application has come into the ISA, then they will focus particularly on the claim part of the specification, not in the formality part. Where the claim part, it contains claims, title, starting from title, and the invention. What does it mean? Suppose if there are more than one claim in the claims, then the question regarding the unity of invention will be arised. The unity of invention is more than two inventions are there in the claim part, then the question regarding the unity will be raised. In that situation, the examination report will indicate why the unity of invention question arise. Accordingly, you will have to comply in future. Same way, where the search authority will not do the formality checking, they will do only the claim checking based on the novelty, inventive step, and industrial applicability. And further, after the examination, they will establish the international search report. International search report and the ISA are quite different terminology here. ISA is the authority, ISR is the report. See, the ISR may contain sometime declaration that no international search report will be established. Means invention is not patentable, not searchable. In that situation, this declaration will be communicated in the ISR. And finally, the ISR report is non-binding to any country. A country has their, the country where the application is enters in the national phase, the application will be prosecuted in accordance with the local law. What is the ISR? In fact, the ISR, International Search Report, and what are the contents will be communicated in the ISR? Importantly, patent classification, indication of the technical area search, indication relating to any findings and the lack of unity of invention, a list of relevant prior documents, indications relating to findings that meaningful search could not be done, and the time limits to establish ISR as written opinion is mentioned in the slide. What actually the ISR and what basis the ISR would be established? That is, we know we all are in the same field, that is the prior art search, that we have to search and examiner will do the search and they will find out the most relevant search prior art documents where it is been published before the priority date. And the same way the analysis about the D1, D2, D3, whatever, and the same will be communicated to the applicant through ISR report. That is called written opinion. Initial, preliminary, non-binding. This is very important. The ISR report is non-binding. Okay? Novelty, inventive step, industrial applicability. These are the three criteria ISR will contain. The once ISR is adverse, then he has a chance to choose and he has to enter into the IPEA, International Preliminary Examination, where the negative report, if it is established, then there is a possibility to get it in the positive report by giving proper explanation before IPEA. That is called International Preliminary Examination. It should be before publication. For entering into the IPR, there is also certain kind of forms are available and one has to make the demand, that payment has to make, then only the IPA will be established. And the payment has to be made directly to the IPA, RO or IB. International Preliminary Report on Patentability. This is to be established within 28 months from the priority date. Indian Patent Office started functioning as ISAIPEA since 2013. At present, there are more than 500 staff officers have been deployed for, they are working in the IS and IPA. Why India is been chosen as opting for IS and IPA? We can see primarily the competitive, very less search and examination fee, opportunity to get expedited examination of application under Patent Act Rule 24C. This is very important. Once the applicant, if they choose the ISA as India, then they will have the chance of expedite the application in the national phase, particularly in India. This is the little bit, the statistics filing of ISA applicants in the calendar year. If you see 23 and 24, in the 24 there are a lot of, the graph has been increased from 2024 to 32. It is a lot of difference is there, and gradually the filing, PCT application, if it increases, in the same way the ISR report, ISA applications will be increases. And this year also, as Rohit told, this year also we are expecting more than what applications have been examined in the 2024. This is the filed and examined status in 24, 2770 examined and 3232 are filed. Whereas in 2023, 2024 filed and examined 1917. Still we have, as on today, we have crossed the target which was earlier was there 2000, now it has gone to the 2770 has been examined. As well as in the IPA, the trend of filing application is also little bit increased, but IPA is not mandatory to file, applicant has to go into the IPA. It depends upon the situation how the ISR report is established. If it is negative, then only people will choose for the IPA. If it is positive, they may not choose it. We are maintaining the quality policy in the IPA, ISA, IPA in our Indian Patent Office, vision, mission, and reliability of search report, etc. These are the fee which is to be paid to the Indian Patent Office and for search authorities, ISA, preliminary, additional fee, etc. All these details are available in the Indian our Patent Office website. You can visit and you can get it. Same way, this is the preliminary examination fee, as well as ISA, IPA, and handling fee, etc. This is also available in the Indian Patent Office website, right? And for communication, particularly in the ISA and IPA, there are certain forms, including PCT, RO, etc. There are certain forms are available. The communication between the office and the applicant has to be made in this type of forms. These are so many forms are there. So these forms, I think it may not be available, and but you can access it in the internet itself. Thank you very much, everybody, for concentration.